Please tell us your name and your roll number for this exam.
My name is Sandeep Panda and my roll number is 400835.
So will you please give some, in nutshell, your biodata?
My name is Sandeep Panda. I have passed my LLB from Madhusudan Law College, Cuttack in the year 2018. I belong to Cuttack. After passing my LLB from Madhusudan Law College, Cuttack, I joined as a research assistant in the Odisha High Court, where I worked from 2018, 25th August 2018 to 15/8/2021. 2 years and 9 months I worked as a research assistant, and after my term got completed as a research assistant, I have been working as practicing now as an advocate, and simultaneously I am preparing for the competitive exams.
So you are attached to a chamber now?
Yes, sir.
Who is your senior?
Actually, my father is a lawyer, so I am working under him.
Which is his name?
Prasanta Kumar Panda.
So, why are you interested for the post of assistant public prosecutor?
My first reason would be my inspirations are my maternal grandfather and my father. I have witnessed them in many cases. They are arguing for the defense or the prosecution, like the defense, mainly of the defense. I have seen them, which inspired me a lot to join in this service. And moreover, another reason is that when I worked as a research assistant in Odisha High Court, while I was sitting in the dais and observing different lawyers arguing the cases, that aroused an interest in me to join that service, join this service, so that I will be also be as a researcher, as an assistant public prosecutor, I will also be able to deliver some type of justice by arguing for the victim or for the state.
What is the responsibility of assistant public prosecutor?
The main responsibility of assistant public prosecutor is to prosecute the cases, cases for the state. Mainly for the state, he argues the cases or fights the cases on the behalf of the prosecution. He prosecutes the cases fairly and impartially and delivers justice to the victims or the state, and that's the main responsibility of the assistant public prosecutor.
During your association as a research assistant, so you were doing this job that was assigned to you.
Yes.
Okay, tell me, if there is a judgment which has been overruled, and there are 5 judgments on this subject, how to come to a conclusion? Which precedent will now work? Which precedent? How the precedent is to be decided? Suppose there is a 3-judge bench judgment, there is a 5-judge bench judgment, and there is also a 2-judge bench judgment of Supreme Court. You are given 3 judgments. Now, some part is relied, some part is retracted. So, ratio, how? Just tell me, because you have worked in the line.
First, the file which comes before me, I will first go through the facts, then the whatever documents they have relied upon or the annexures they have relied upon. Then I will go through the research work, which as the Honorable Supreme Court has given 3 views on the same point. Means the 2 bench judges, then 3 judge benches, all the particular case laws I will cite them. I will, after citing them, the case law which is held later on, means the last one which was held, that is the 5-judge bench, then I will highlight that properly. Other views are also to be accepted, not that they will not be accepted. And that means the view which was overruled, particularly that point of law which was overruled by the 5-judge bench, that I will highlight it properly, so that the honorable judge to whom I am attached, he will not be confused on the point of law I gave. means that 5-judge bench he will more rely upon that as compared to that 2-judge bench or 3-judge bench, and more the 3-judge bench or 2-judge bench while dealing with the case, the 5-judge bench might also have relied upon that or dealt with that issue, and he would have also have given a view on that viewpoint on the 2-judge bench as the 3-judge benches. So the latter view is more correct as compared to.
So what is the law precedent?
Law precedent, we can say that means the latter view or the latter point, which is means first a point is decided by the court, and another on the same point another view is also held by that court. So the latter view is to be held as a precedent or the binding precedent on the honorable division or honorable subordinate benches or the subordinate courts.
So what did Supreme Court, there was a view, established view.
Yes, sir.
And the Supreme Court later on, a 2-judge bench or a similar bench did not refer to that judgment and delivered another judgment, another view. So which one will prevail?
Then it should be referred to a larger bench. The larger bench view should be always be held, because there is an inconsistency in 2 views, and the inconsistent views may not be applicable, means may not.
No, I say very particular. There was a view.
Yes, sir.
Okay. Now the Supreme Court delivered another view,
Yes, sir.
but didn't refer to that view. He didn't cite that case.
Okay. Okay, sir.
Totally, the judgment is silent about that case. He delivered another view, as if it was not cited before him.
Okay.
So which one will prevail and what will be?
In that case, both the views can be taken into consideration. Then the view which is more favorable or more appreciable in the opinion of the honorable judge who is citing the judgment or making the judgment, then that view will be, because both the views are to be considered, as the one is not been overruled by the honorable apex court. So the view which is latter held, or the honorable judge will look at both the decisions, and he will see that whether that view taken by the previous bench has been referred to the latter bench. If it is not referred, then he will rely upon both the judgments, and which is more appreciable or which is more befitting to the case, then he will cite that case.
If the earlier view
Yes, sir.
is not referred,
Yes, sir.
then that will be a precedent, not this. Because that has to be relied upon. Yes, relied that, referred that, or followed that.
Yes, sir.
Not there.
Yes, sir.
Either you can rely, or you can refer, or you can follow.
Yes, sir.
So either of things without doing, you could deliver a judgment, the same subject.
Yes, sir.
Then as far as the law precedent,
Yes, sir.
that judgment will work
Yes, sir.
for itself.
Yeah.
But when in a second case, both are cited,
Yes, sir.
the earlier will be followed. Because this judgment has been delivered without following that judgment.
Yes, sir.
Okay, good. So, what sort of practice you have now?
Mostly criminal practice.
Criminal.
Yes, sir.
In which trial courts or high court?
No, only in high courts.
Only in high court. So, in high court, what type of cases? Except bail, nothing happens there.
Bail and sometimes also criminal appeals.
Criminal appeals.
Yes.
That's also stage of bail. Have you ever come across any argument in a criminal appeal?
Yes, I have come across an argument in criminal appeal. Recently, my father was arguing a criminal appeal. It was relating to some vigilance case where the accused was dismissed from service, his salary was withheld, like that, something like that. A vigilance court has
dealt with in a service-related activities dealt with in a criminal appeal.
Yes, sir. It was dealt in a criminal appeal. The accused was in a state bank officer. He was some misappropriation he has made during his period of service, and he was dismissed. Moreover, a disciplinary proceeding was going against him. Moreover, a vigilance case was also instituted.
Whether can be initiated or not?
Yes. Yes, it can be initiated because disciplinary proceeding. Because
jeopardy will not come into play.
Disciplinary proceeding is something different in the context because it is dealt under the service code or to which that employee belongs, and the criminal proceeding is somewhat different. It deals with that accusation or acquittal or the conviction of that particular employee relating to that.
Here it will be punished, there he will be.
Yes.
But what is the preponderance of probabilities and benefit of doubt? What's the scope and ambit?
Preponderance of probabilities means court will weigh both the probabilities, means it will weigh the evidence. The more it leans towards the one party, the court will act on that. The means that weighing balance, that more that leans towards one party, it will act upon that, more upon that view, and the other view will not be accepted. And in case of benefit of doubt, means a prosecution has to prove that case of the accused beyond all reasonable doubt as per section 101 of the Indian Evidence Act. But when he fails to prove that case, or there is a lacuna in the case which will be in favor of the accused, then court will give a benefit of doubt to the accused, and he shall also be entitled to be acquitted on that basis.
Can you give me an example? Not proved, the stays when it has been not proved. Proved, I understood. Disproved, I understood. What do you mean by not proved?
When it is neither proved nor disproved, then it is said to be not proved as per the Indian Evidence
Then
Act.
what will be the consequences of that case which has been not proved?
Sorry, madam.
Tell me one more thing. What is the difference between culpable homicide and 304A, rash and negligent act, death caused by rash and negligent act? What is the difference?
In culpable homicide, we can have that culpable homicide amounting to murder and culpable homicide not amounting to murder. But 304A, it specifically deals with rash and negligent act, and it has been provided that it shall not amount to culpable homicide as provided under section 304A. And
that means shall not amount to culpable homicide means what it is indicating?
Means in culpable homicide there is a particular intention or knowledge to kill that person or kill that but in 304A there is no such particular knowledge or intention. It is without any knowledge or intention.
Okay. So tell me one more thing. If a woman dies after 7 years of her marriage, in dowry torture and dowry death, whether that will be coming under dowry death or that will be a murder after 7 years?
After 7 years it will come under murder, because dowry death within 7 years of marriage. So after 7 years of marriage it will come under murder.
In case of a dowry death, what is the most important ingredient? If in case of dowry death, what will be the first essential thing the court has to see?
First one, she should have been married.
Right.
Within 7 years of marriage her death must be caused by burns or otherwise under normal circumstances or by bodily injury. Then she must face a direct torture from her husband or a relative of her husband relating to the means giving of dowry or taking of dowry, like that. Then it will.
And what was the most important term? You missed that term. Whether it's soon before her death or not, right?
Yes.
If it is not so soon before her death, like if the torture was, for say, it's been 5 years to the incident or 10 years, 6 years to that incident, whether still it will be counted as dowry death.
Honorable Supreme Court in Kansraj versus State of Punjab has held that it cannot be laid down as a straitjacket formula. What is the soon before her death?
Right.
Even in 2000, recently the Honorable Supreme Court has also held that soon before her death cannot be given a straitjacket formula. It cannot be cut and dried. So it should be proximate. Not that it should be cut and dried and it should be like a formula it should be applied. So it should be proximate to the cause of death.
So what is the evidentiary value of a co-accused?
Evidentiary value of a co-accused can be said that if he is stated as if he has been granted pardon under section 306, then he becomes an approver. If he becomes an approver under section 133 of the Indian Evidence Act, he is a competent witness against an accused, but his testimony is not illegal because it proceeds from an uncorroborated testimony of an accomplice. But in 114, against there is a contradictory view that an accomplice is unworthy of credit unless he is corroborated in material particulars, which the Honorable Apex Court in various decisions starting from the Privy Council in various cases, section 114 has been held to be a law of practice, but section 133 has been held to be a law of prudence, So, as a law of prudence, court will look for the corroboration of that accused person, co-accused person, and even if that co-accused person gives that evidence which may be favorable to the accused, it can be safely relied upon that evidence given.
So, how you differentiate between section 30 and 133? What is the difference?
In section 130 and 133, section 30 deals with the confession where there is a joint trial, but in 133 there may be a joint trial or may not be joint trial.
Whether it has been written under 133 or it is an interpretation?
It is an interpretation. It is not provided under 133, I think so.
Okay. So, is there any difference between an accomplice and co-accused?
Accomplice, again, co-accused, there is not much difference, but means co-accused is a person who is actively involved in the commission of that offence, but we can say that accomplice is accessories after the fact or before the fact, or the means after committing of that offence he helped him to bury the dead body. That means he can be said that.
Okay. So tell me one more thing. Whether a person who is in coma after giving a statement, whether his statement will be counted as dying declaration, who is in coma, no recovery, chance of recovery, still that will be a dying declaration, or is there any other provision under which the statement will be taken by the court as a relevant fact?
It was recorded as a dying declaration. Yes. Unfortunately, the put to coma, and doctor says no recovery, only God knows when he will die.
So when he dies, then in that case it can be considered as a dying declaration. But if he does not die, then he may be. If he does not die, then it cannot be considered dying declaration, but it can be considered as under section 157 of the Indian Evidence Act as a corroborative evidence. So all the court will consider all the views, all the circumstances which will be, means when he is called as a witness in that sense, he will consider all the aspects, and then he will take that evidence into consideration, provided that his statement must relate to the cause of the death or circumstances leading to his death.
So can you tell me what is the provision under section 5 of Indian Evidence Act?
Section 5 of the Indian Evidence Act mostly deals with that evidence may be given of relevant facts and of no others.
Right. There are two things, right? One is relevant fact and one directly connected to the facts in issue. Just give me one example of that first rule. If any fact is directly connected with facts in issue, that can be given as an evidence. So tell me one example of that. Relevant, I understood, anything comes under 6 to 55, we will be taking it as an evidence, right? So tell me an example of a fact which is directly connected with facts in issue and that can be an evidence.
We can take that as a res gist as an example.
Res gist is coming under section 6.
That is connected with the same transaction, then it can be taken as.
Section 5 says about there are two parameters, right?
Yes, sir.
One is any fact connected directly, that can be an evidence, or any fact which is relevant, that can be used as an evidence. So relevant fact, I understood, that's come under 6 to 55.
Yes.
I'm only concerned about the first statement.
Yes.
So just give me one example when a fact, even if that is not coming under relevant fact, 6 to 55, still that can be given as an evidence. Just give me one example. Just justify that first line by your example. Fine, thank you.
What have you prepared for? Give it a sheet to.
Does that, sir?
Still there is time.
Still there time to that. Do it तुम्हें humble करो चला ठीक आपको देख दो और बहुत head move करते हैं आना चाहिए
तो expression था normal बदलने
tense
as if an court case कला वाले से situation टा ऐसे because there is a confrontation, but normally interview is not a confrontation, court a confrontation होगा because something will happen then and there. Say jinsataku take cool call. Say that. I think it will be